Welcome to this 34th MardiGrass. And it's a tradition to kick it off. It's a tradition now, I'd say, isn't it, Steve? You're always here for the legal advice session. David, you're mostly here for the legal advice session. I think when he was a magistrate, we couldn't have him, probably. Anyway, I recommend you follow the program because we'll stay on time. And where is Miss Guidance? That's her, busy, walking towards the back door there. I want you to all thank her. She's organised this Hemposium. That's you, miss. That's enough of talk about her. Anyway, thank you so much, you two guys. I've told people on the street, any legal question, it's all here for free. Thanks heaps.
Morning, everybody. I'm Steve, that's David. First of all, welcome everybody to MardiGrass. This is number 34, is that what Michael said? Who pays attention to Michael? I think he said 34. It's certainly a large number, and I've been to 32 of them or something like that. So it's old times for some of us, and first time for some people here, perhaps in the mob. Should begin quite properly with acknowledging that the country we're on is not our country, it's Aboriginal country. The Widjawaiwa people of the Bundjalung Nation have had this land under their custodianship for who knows how long, how many tens of thousands of years, 60, 70, who knows. The number gets pushing back. And it's proper and right that we should always keep that in the front of our heads. I reckon we're colonial, my mob anyway, we're colonialists. We've been here for a few generations, my family and my ancestors, but she's a pretty short time in a continent that's millions of years old and with a population of 50, 60, 70,000 years living here before us, doing such a good job of looking after it, and us white fellas haven't done such a great job since then. So I think the least we can do is acknowledge it, and we do acknowledge that with proper respect for the Indigenous mob who've been here for so long. I'm going to talk for about 10 minutes or maybe a bit longer about just an overview of the legal arrangements about cannabis, and then the rest of our hour or thereabouts together is for questions. So when we get to the questions, if you could please put your hand up so we have people aren't talking over each other, and there's a roving mic so that everybody else can hear the questions and the comments that you're making. So we'll get onto that momentarily. But the first thing to say about cannabis is that it is illegal. That is, cannabis is a prohibited drug in New South Wales under the legislation. There's a couple of exceptions about a prescription. If you've got a cannabis prescription, then you're entitled to possess cannabis. If you've got a license, you may be able to grow cannabis, but they're pretty rare exceptions. Generally speaking, for most of us, it's an offence to possess, supply, grow cannabis, have any kind of dealings with cannabis at all. To understand that, though, I think we need at least a bit of a general idea about how the legal system works. So a very short overview about the criminal justice system. For the police to for a person to be found guilty of a criminal offence, that is an offence that, conduct that attracts some kind of penalty or fine or jail, wherever it might be, generally speaking, the police must prove to the court beyond reasonable doubt that you're guilty of that offence. We pretty much know that. That requires evidence, and the evidence depends on the nature of the offence that the police are trying to prove against you. If it's an assault, if it's possession of a drug, if it's a driving charge, whatever it might be, the police need to prove to the court that you have done the conduct, but in particular that you fit within the what's called the elements of the offence that's being charged. Which court you go to in the system depends on how serious that charge is and how serious the system considers it. So for cannabis, depending on your conduct, whether that's possession, whether that's supply, will affect what charge you might be facing. If you're found in possession of cannabis, you're charged with possession. If there's evidence that you might be supplying cannabis or growing cannabis, you're charged with cultivation or supply, as the case may be. The court you go to depends on the nature of that activity, alleged activity, but also the quantity of the amount of the quantity of the drugs involved. So, broadly speaking, most offences, and this is true of all criminal charges, something like 91, 92% of charges in New South Wales are dealt with in the local court. So the magistrate, now called a judge. The judges in the local court will decide whether you're guilty or not and impose the penalty. More serious charges can go to jury trials in the higher courts, that is, large commercial quantities and so on. Police have the power to give a caution for possession of small quantities, so there are all sorts of rules around that. If the quantity involved is less than 15 grams, then you might qualify for a caution instead of going to court, instead of being criminally charged, and that means obviously a reasonably better outcome than not being charged, of course. Not the best outcome, being let alone completely is the best outcome, but at least you might qualify for a caution. You have to have no prior convictions, there has to be all these rules and so on around that, so many people don't qualify, and there's a fairly small number, could be a larger number of people get cautions that are actually issued. The police have a discretion and they could use that more often, but they do it sometimes. Otherwise, any other offending, though, is a matter for going to court. When you get to court, if you're found guilty, come back to some of these other things in more detail, the best result you're going to get in court is having no conviction recorded against you. That's under a provision called Section 10. So if you get no conviction, then that means you can tell employers and so on that you are not convicted. It's a useful result, and there's often no other penalty. Sometimes a good behaviour bond, but no other penalty. Otherwise, there's a range of penalties that increase in severity, from fines, various types of good behaviour bond, jail terms, and a kind of a type of good behaviour bond that's called an intensive corrections order, which is a make one mistake and you go straight to jail kind of good behaviour bond. Looking at the local court statistics from the last year or so, there were, in New South Wales, 9,700 total drug offences total possession offences in New South Wales. That includes all drugs, not just cannabis. And of those 9,700 total offences, 7,600 were for possession. So, as we all know, it's the bottom end, I suppose, of the market that gets policed. It's the people who are users and possessors of the drugs that are most in trouble in terms of representation in court. Of those 7,600, about 1,300, about 17% on my maths, about 17% got no conviction recorded. So not too bad, really. A lot of those people would be first offenders, small quantities involved, etc. The most common penalty, though, for possession was a fine. About 5,000 of those people, 65%, were fined. For cultivation, the Bureau of Crime Stats has a sort of slightly weird way of doing the grouping, but what they classed as commercial, 50-50 whether you got to jail or not. 50% got the ICO offence or penalty instead, and for what they described as non-commercial quantities for cultivation, ICOs, good behaviour bonds and fines were sort of spread fairly easily, or equally, I should say. For supply charges, about 60-40 for what they classed as commercial, 60% go to jail, 40% don't, and for less commercial quantities, 25% went to jail and the rest were sort of spread around. So depending on the how much trouble you're in, certainly jail is a possibility. If it's not your first offence, jail becomes a possibility. If it's a reasonable large quantity of cannabis, jail becomes a possibility, and you nonetheless have to, I suppose, cope with that. Driving is, as I think everyone in the room knows, it's an offence to drive with the presence of THC in your saliva or blood. They only test for saliva, and that can be presence, that can be the result of use of cannabis. It might be a day, 2, 3, 4 days previous to the driving. The system these days is, if you are a first offender, you get a fine, basically a penalty notice. You get to pay the fine, some time to pay the fine, $705, I think it's something like that. And you get an automatic 3-month loss of licence. If you are not a first offender, you go to court, and the judge in the local court decides what sort of penalty you get. You can get a Section 10, no conviction. If you are not convicted, you don't lose your licence. If you are convicted, you must lose your licence for a minimum of 3 months, 6 months for subsequent offences. So it's a fairly significant penalty, you'd have to say. Again, statistics from the last year or so, New South Wales Police, I'm not sure of their number, somewhere between 150 and 200,000. David might have a more recent number. But the police are wanting to test 200,000 drivers every year for drugs in New South Wales. Pretty high number, I reckon. Anyway, a couple of years ago, they did 156,000. Not sure of the last year whether it got any more than that. Of that, from the statistics, 10% of those people tested tested positive to a drug. A fraction more methamphetamine than cannabis, so it's 50-50, really close to 50-50 for cannabis and methamphetamine, but methamphetamine is a little bit higher, so 53, 47, that kind of percentage breakdown, and a small number of people testing positive to cocaine or MDMA. Last year, for the first time, I reckon, there were 10,000 people charged with, in the court system, with driving with a presence. So 10,000 went to court, about 5,000 or so got the court attendance notice instead, got the penalty notice instead. But there were only 8,300 PCA offences, drink drive offences. So for the first time, there were more people in the New South Wales courts on driving with presence, drug driving cases than driving with alcohol on board. So that tells you something, I reckon. Of that, of those people that went to court, about 900 of that 8,000, 900 or so got Section 10, got to keep their licence, 7,000 got fines, 2,000 got bonds of various sorts and so on. So the risk of losing your licence if you test positive to a drug is, you'd have to say, very high, maybe 10% chance of getting away with it without loss of licence. I can't hear you, and the reason I can't hear you is the acoustics
you have
are terrible.
to wait for a microphone. Here we go.
Oh, thanks for that. Can you just wind back a bit to the numbers that you said were people that were caught with PCA? There was something like 9,000 in there.
That's right.
And you mentioned that the drink driving laws, that the drug driving laws were more than the drink driving laws.
More than the alcohol, that's right. The alcohol offence is called driving with a prescribed concentration of alcohol, PCA. So the breath test for alcohol charges that went to court were 8,300. The total drug driving cases were 10,000. Okay? I know I said that quite quickly. The last thing I want to say, and then we'll have questions, we can talk about this in much more detail. Obviously, this is a really rapid overview and leaving some of the niceties and the complexities out of it. But the question that's always, that we will spend probably the rest of the hour talking about in some ways, is what do you say to police when you're confronted with police? What's the best approach? And the answer is it really depends. Lawyers always tell people, or advise people, best not to say anything to police. My experience as a lawyer, I was a lawyer until 12 months ago, I retired, but I was a lawyer for a while. And my experience is that people always talk. People always say something to the police. If you go to court and you've got a police fact sheet, police summary sheet, they almost always have something that the defendant has said to the police. Anyway, despite that, lawyers press on and say, no, best if you say nothing. The reason that lawyers say that is that it goes back to the question of evidence. For the police to prove something beyond reasonable doubt, they need evidence. That's obvious enough. But the evidence can be admissions that you make, things that you say to police, admissions that, yeah, that's my weed. Yeah, I grew that. Yeah, I was going to give it to my friends. I might have sold a little bit. The more you say, the more you tell police, the more they have the potential to ramp up the charges against you, to add other charges. And the best approach really is to say nothing or as little as possible and then see where you get to in terms of what charges might be laid anyway, because it doesn't avoid being charged, and then get some advice about whether you might plead guilty or not plead guilty. Again, overview, most people plead guilty. Drug charges and all other offences, 90-something% of people plead guilty because the evidence is usually pretty strong in most cases. But there are legal arguments and there's issues about the evidence rules and so on that you might give you a better chance than you might think. So overall, best to say nothing, or at least keep that in the back of your mind, that you're entitled to silence. It's one of our few civil rights is that we're entitled to silence. You don't have to say anything to the police. Give them your name and address, that's all. But if you do say something, then you are going to talk yourself into possible trouble. Best approach is if you think you might be facing some kind of serious charge, cultivation, for example, then have something organised to say. Have some form of words in your mind about what you're going to say to the police. Then just say it over and over. You might say something like, I'm not going to make a statement until I talk to my lawyer. I'm not going to make a statement until I talk to my lawyer. Say it over and over again, and eventually they'll stop asking you questions. To get a caution, though, you have to make an admission. So it makes it difficult to give broad advice about what to say. For many, many people, the stats show it. Most people who are in a conversation with the police about a drug offence will be about a possible possession charge. To qualify for a caution, you have to make an admission that the drugs were yours. So many times you're going to do that.
And Steve, we have a question down the back here.
I'm about to finish, so I'll come to questions in 10 seconds. I'll just say one more thing, and that is with the driving offence, in terms of talking to police, what you say to them doesn't matter. To prove the driving charge of driving with the presence of THC, all they need is, there's the swab process, we can go through that if you need to, but there's the police take a sample of drugs, send off to a sample of your saliva, I should say. Sometimes that's drugs with saliva in it, sometimes it's saliva with drugs in it. But that sample goes off to the lab. If it comes back as a positive result, then that's what they rely on. What you say to the police doesn't really matter. It doesn't make you guilty or not guilty. It's the evidence of what's in your saliva. But what you do say to the police is recorded, put down on the summary sheet that goes to the magistrate, goes to the judge, and if you say to the police, well, it's 2 days since I had a smoke, what are you doing? Then that is in front of the court. So it might be worth saying that. The only thing I would say is that if you have a prescription, it's not legal to have a prescription and drive. That law has been kind of announced but hasn't happened yet. Maybe it won't happen for a while. But if you have a prescription and you tell the police you've got a prescription, sometimes the police will not test you, sometimes. So if you've got a script, tell the cops you've got that. Avoid the sampling, the swab being taken altogether. Once they take the swab, things sort of take their course and it's hard to get out of it after that point. But if you can avoid the swabbing by saying that you're telling the cops that you've got a prescription, then that's a useful approach. That's me talking a lot. I'll let David get a word in, and then there's a question.
There's another reason for having the script with you as well, and that is because then you can show the script, and then when it does go to court, having a script makes a difference in terms of the penalty that might apply. I just wanted to add that Steve and I have been involved in drug law for a combined total, I thought, of 80 years. We wrote a book together in the 1990s called Rough Deal, Your Guide to the Drug Laws, and much of that still stands. I've still got a copy of you.
No.
But my involvement with drug law started because I was in practice in this area, and it was in this hall that I gave my first speech on drug law reform at the very first MardiGrass when Michael Balderstone, myself and Bob Hopkins arrived at the police station. And you can Google that and see that footage to this day as it is. But there's something I wanted to add. Steve's the nice guy, I'm the angry man. That 7,000 figure of people charged with possession of prohibited drugs in New South Wales is more than the entire nation of people charged with sexual assault. Let that sink in terms of policing priorities. It never ceases to infuriate that the police would rather police a drug possession than they would investigate, prosecute and charge for sexual assault. The 5,000 people that will lose their licence in New South Wales courts every year for driving with a drug as a result of THC in their system, a result of random test, is more than the entire rest of the world lose their licence for drug driving because no one else does the kind of random testing that we do here. So all law, and we're happy to give legal advice, has that context. And I know you're here for legal advice, but let's get motivated to change the world at the same time. There'll be a lot of talks in this hall over the weekend. Always is. We've got an incredible array of politicians, including for the first time in many years a Labor politician. And we also, and if you're interested in talking about race, class, gender and the drug laws, I'm doing a talk at 1:45. Let's go with the legal questions.
Can it be appealed?
Sorry, there's a question at the back.
Yeah,
somewhere
let us
first.
come with a microphone, please.
Hand up, we'll get the
And
mic
put
to
your hand up. So who's first? Put your hand up, please.
Sorry. Can the law be appealed in the basis on the grounds of common sense? Because seriously, it's a spectrum there of people who smoke. For example, some people smoke just to relax, and some people they smoke to get trash. If you're just relaxed driving, it's less likely to create an accident. But if you are trash, well, it's more likely that it could happen. You know what I mean? So we need something like we do with the alcohol. Have a limit. So no deny of smoking or using pot, but a limit to it.
We have two, in drug driving, there's two kinds of laws. One is a presence law and one is a driving under the influence law. Presence works for alcohol, but up to a limit. But cannabis, it's any presence whatsoever, and they test to 5 nanograms. That's 5,000 millionths of a gram. So we're talking about teeny quantities. So, and your point is well made, but if you remove the drug driving laws tomorrow for presence, you would still be left with driving under the influence laws, which means if your driving is adversely affected, you're weaving all over the road, you're sucking on a bong as you're driving along, and you're a danger, you will still be guilty of a crime. So those sensible laws still exist, always have existed, at least since the 1950s, and should remain. No one's arguing that driving under the influence laws should be changed. I'm not. And they apply to all drugs, all prescription drugs, and all illicit drugs. But the presence law is there, even though it is completely stupid, and no, you can't appeal to any court on the basis of it being stupid, because Parliament has determined that this is the law, and only Parliament can change it.
Just adding one sentence to that, really, and that is that judges and lawyers are trained, and the system operates on the basis of not on what you think is a good or feels good outcome, but in terms of rules and some consistency. And so a good thing about the legal system is that there are some principles and consistency, and you can kind of predict what might happen in a certain situation, which is probably better than totally randomised results. But yes, it also means that there's no kind of judge able to say, oh gee, that's a stupid law, I'm not going to apply that. That's not how they're allowed to do their job. They don't last long if they do.
We have another question here, down the back.
More just a comment, though you may wish to address it. In terms of people getting busted, if you are in a group, it is absolutely imperative that you all say nothing. There is a precedent, Filippetti versus Crown, in which they need to prove exclusive physical control. I've been busted sitting in front of a big bowl of marijuana and 3 bongs, went to court, yep, there's marijuana, I knew it was marijuana, all of that sort of stuff, but it was not mine. I did not have it in my exclusive physical control. What the police would have needed to do in all circumstances would be to arrest everybody involved and then either prove or disprove possession on each person's case. So that's something to bear in mind. There are ways of easily getting out of what seems to be an irrevocable situation. So, and it would be really good if we push more of those ways to get out of charges.
Well, largely correct. I don't have much in dispute with that. When Steve and I wrote our book, Rough Deal, Your Guide to the Drug Laws, we had a section, I don't know if it was actually called this, but it was something like the heading was Where to Store Your Dope. And it was, in a public area where everybody in the household has access to it. because that way it's very hard for the police, in the absence of admissions, to prove whose drugs it was. That's based on Filipetti's case. So thanks. Did you have something you wanted to add?
It's just a really good example about why you should be very careful, at least what you say to the police. It's a classic example, really. The police might be entitled to conduct the search. There's all sorts of issues and laws around whether searches are valid or not, but leave that to one side. If you're in a situation where there's a query about whether you are in possession, that is, whether you have the control over something that might be near to you, it's not an offence to be close to cannabis. Doesn't make an offence. You've got to have some kind of degree of control, as the questioner said, over the substance. If that's in a car that you own in your glove box, well, okay, that might be a pretty strong indication. But if it's in a group house, in a car with 3 other passengers, for example, just because you own the car doesn't necessarily mean you own what's in the glove box. If everybody says nothing, then you might avoid the charge, or you might at least have a case to plead not guilty and fight the case in court. The thing it's always worth remembering is that what you say to the police doesn't matter in the sense of making an early admission. If you make admissions to the police, you've added to the case against yourself. If you say nothing, get charged anyway, go to court and plead guilty on the first time you get to court, you get the maximum result in terms of reduction of penalty by pleading guilty in court rather by pleading guilty to the police, if that makes sense. So keep your powder dry, as the old saying goes. Try to keep a cool head on your shoulders if you possibly can. We're all cool. But stay cool in terms of that situation. It's often confronting and a bit scary. But if you think through what you're going to say and say nothing, or say very little, and try to sort of keep your wits about you, then you could end up with a much better legal outcome than you might expect when the police knock on the door.
I was just going to add, there's a really funny, I think it's funny, exception to that, and that is the forgotten drugs. The case was this guy had a joint behind a painting in his room, and the police invaded the house and, with a search warrant, etc., and found the joint. And he goes, "That's where I hid it." And you notice he didn't sort of have exclusive physical possession of it. He had even forgotten where he put it. Anyway, he was found guilty. So, yeah, just a little exception. Don't lose the joint. Yep.
And it's wrong in principle, because if you don't have any knowledge anymore, then you should be found not guilty. The judge said, "Oh, well, we can't let people who've got bad memories off, so we'll find you guilty." But really...
Yeah, well, hey, we'd be all right.
Sorry, next question. There was a hand up somewhere. Yes.
I'd be grateful if you could answer a question that puzzles me, and I know many other people, and that is, for cannabis law reform, effective cannabis law reform to take place in Australia, what has to happen? Does the Commonwealth have to change its laws? Do all state and territory governments have to change their laws? Do all 9 governments have to change their laws?
It's a really good question. During the Howard era, the federal government tried to cover the field by introducing its own possession charges. Traditionally, the division has been this, that the Commonwealth is concerned about importation and exportation of illicit drugs, and the states have things like possession, supply, and etc. So then Howard decided, because some states were making little movements about changing the law, decided, well, we'll cover the field on that because it's connected to import and export, so we'll have laws that relate to possession as well. So where does that leave us? Two things. Firstly, if New South Wales were just to change the law to legalise cannabis, then it would still be illegal under federal law, but history would show that that would not ever be enforced. And the history that I refer to is what's happened in the ACT, because the ACT government has decriminalised most drugs and no one gets charged with the federal offences of possession. Now, it happens that that has occurred during both Liberal and Labor, or Coalition and Labor governments, so, hang on to the possibility that whichever state or territory decides, the Commonwealth won't interfere. And that's incidentally exactly the same situation we're seeing in America now, where a lot of states have legalised, and even under conservative Republican governments, they haven't been charging with people with the federal possession offence that they could have. So that's the first point. The second point, sorry if this is a little bit technical, but David Shoebridge will be speaking tomorrow, and he has a bill, and he has in his possession a legal advice from one of the best constitutional lawyers in the country, who says that the Commonwealth can legalise drugs, that it has the power under plant laws to legalise drugs. So he put up a bill saying that, you know, let's legalise drugs right throughout Australia. And lo and behold, our wonderful government and opposition voted against it. So it hasn't got a hope of getting up, despite, well, you know, I mean, David is an extremely convincing, wonderful person, and maybe he'll succeed. So, short answer is we have two tiers, but really the states and territories rule by convention, and also no one's ever tested whether the Commonwealth really does have the power for people to be charged federally under the Crimes Act as a result of the import-export power. It seems like a bit of a stretch to me. Is that a reasonable summary of where we're at?
Yes, I'll just say one thing is, as far as I know, no one has ever been charged under those federal provisions for possession or supply. So they're on the books?
You know, they only once have I seen it, and that is where someone's charged with importation and possession, because they've imported it, then they've possessed it. Does that make sense? Or they're the person who, you know, someone else has a mule and delivers it to them, then they might get charged with it, because it's so closely associated with the importation. But we don't have, fortunately, federal police or state police running around charging people with a federal offence.
Okay, we have a question here. We'll come to you soon.
I'm going to go back a little bit. You were talking about getting caught with pot in your house and pot in your car. Is the difference because when you are in a dwelling place is one thing, and when you are the captain of a vessel, all right, you are responsible for its cargo?
Yes and no. Look, sadly, a lot of common sense sort of has to go out the window, as the saying goes. The police must prove, for a possession charge, that you had some kind of physical
connection to it,
control, a physical connection with the drug, and a right to control it. Okay, that's sometimes expressed as the right to exclude others from possession of the charge. So one illustrative example is there was a group household, and police walked into the room, and there was some drugs on the table, and one of the people around the kitchen table put a newspaper or something over the top of the drugs. Okay, pretty simple kind of reflex action. Because they took some steps about exercising control over that drug, they were found guilty of possession. Okay. It doesn't, though, apply to everybody who's in a vessel, was the word you used, on a boat. The captain isn't responsible for what everybody owns on that boat, okay? In your car, you've got 3 passengers in your car. You don't know what's in their pocket. You don't have to know what's in their pocket. You don't have to know. You're not responsible for that, okay? So, depending on the whole factual situation that you might be in, depending on what you say, the police comes back to it. But if you say nothing, make no admissions, and the police have to prove from the physical circumstances that you must have had control, you're the only person in the car, it's in your glove box. Drugs found in your pocket, okay? Very, very likely you know that they're there. You have to know that the drugs are there, and you have to have some control about it. They're the 2 elements, knowledge and some kind of control, okay? So all sorts of situations in group households, etc., where there might be more than one person who's potentially the possessor. If they charge everybody with possession, then maybe nobody's found guilty because they can't prove the connection. That's just a waste of time for everybody involved, including the police, and so often they won't bother to charge anybody.
Now, one more question. Can you refuse to be searched until you get your lawyer?
The best, yes and no, again. The best approach is to search. Again, there's a whole lot of law about whether a search is valid or not valid, okay? If the search is considered by a court to be invalid, then all the evidence obtained from that search is not admissible in evidence and often won't be allowed. Sometimes they do anyway, okay? So if you're being searched, you resist that search, that's a charge of resisting police, okay? If the police have a reasonable basis to search you. You won't know whether the police are reasonable or not reasonable until after the event you talk to a lawyer who will go, I think that's reasonable, mate, fair enough.
What about if I don't consent, though? No refuse, just not consenting to it
That's
until I get my lawyer.
That's right. So it's best not to resist, best not to refuse.
Yeah, no, obviously.
But if you say to the police, and they should have their camera turned on, all police these days have a camera on their chest, sort of a recording and what's happening, whatever the expression is, a camera anyway, video camera.
Body-worn video.
Body-worn, thank you. Couldn't remember that word, body-worn. Hard word to remember early on a Saturday morning at MardiGrass. If you say to the police, I do not consent to the search, I'm not going to resist you, but I do not consent, then there is evidence you have not consented. Most people will just say, yeah, okay, you can search me if you want, go ahead. Then you have consented. The police may not have had a valid reason to search you, but because you've consented, that all doesn't matter anymore, you've consented. So express your lack of consent and then let them do it and see what happens after that. Okay, there might be an argument to have with in court at some later time.
We have a question here.
My question is about what your obligations are as part of an RDT. I heard David Shoebridge speak once about when he got pulled over for an RDT. My understanding is a little swab thing, you have to put it on your tongue and then scrape it. And David said to the cop, you can't force me to scrape it. So he just put it on his tongue and gave it back to him is what I assume. And I've always wondered, well, why is that? Is that true? Is that the case? So what is your obligations in an RDT?
Yeah, the short answer to that is there is you can't be charged with having a detectable level of a drug in your system, but you can be charged with refusing to take the roadside test. Now, in Victoria, for example, this happened to Desi Freeman, who he refused to take the test, and in Victoria, the penalty for that is a 2-year disqualification. So, and in New South Wales, the refusal to take the test is also higher in penalty than the minimum for having the drug in your system. So, there's a calculation you need to do, and that is this. Yes, you can refuse the test, but you may well be charged with refusing the test, in which case you can be arrested, you can have your licence suspended, and when you go to court, the minimum penalties are higher than if you were negative, you tested positive to the test. So he's right, you can refuse, but there are consequences for the refusal that, in my experience at least, are far worse than taking the test.
Agree.
And so, love David dearly, but don't take that as advice to not do the test.
Do you have a question?
Oh, hi. Thanks, guys, for coming out this morning. Quick question, or just really, if you could, because coming back to people with scripts. Now, scripts weren't around, obviously, when you guys wrote the book. So, can you extrapolate a bit more on, like, the emergence of scripts in the system and people saying? And secondly, you mentioned something before about if you're pulled over and they offer you a blue tab. You said to mention straight away that, oh, hang on, I've got a script. And that leaves it up. Wouldn't that automatically be an admission, like on the spot? Because if I was a policeman and someone said that to me straight away, I'd be like, right, search the car straight away. So anyway, just to those 2 points.
In the real world, police you'll get pulled over. A cop comes to your driver's window and they'll say, yeah, where's your license? So there's this conversation that they have with you before they bring out their swab, okay? So my advice would be when they pull out the swab and say, I'm about to, whatever. So usually the first thing they do is ask for your license, have some kind of conversation while they pulled you over, be you speeding, mate, or something, or this is just a random stop, whatever it might be. They will usually do an alcohol test, the breath test first of all. I'm going to blow into this, I'm going to get you to count to 10, and blow into this, okay. And then now I'm going to give you a drug. And when they say I'm about to give you a drug test, that's when you say, look, I've got a script. Maybe you don't want to do that, okay? So yes, you're right. Don't raise that the first thing they do when they come over to your window. But when they are about to do the test, they might just wave you on. They might do the breath test and then wave you on. That's clear, you can go now. They might wave you on.
And the second part, wouldn't that just lead to a search? That would not be lawful grounds for a search of a motor vehicle just because you show them a script. And evidence that they then found would be subject to the rules that were mentioned previously. But keep this in mind. There is a significant number of tests that are random. I got randomly tested as I was driving out here. I mean, it's not really random, is it? You know, why are they here? I mean, just fuck off and do something useful, mate. But they are here, but there is also a whole series of tests that are not random because they are generated by the registration plate detection system. Now, if you've ever seen that in operation, there's videos of it where you can see it. It is almost instantaneous when they drive by a car if there is an alert. And that alert is for a previous drug driving charge or drugs associated with that motor vehicle. So there is a series of, part of the reason for that 10% figure that Steve mentioned before is not because they're random drug tests, but because they're using this and intelligence to bust. So if you've been busted once before for drug driving, you will be pulled over an enormous number of times. I have lost count of how many times I've been pulled over for drug driving, you know, very, very regularly.
Not drug driving, though, you should say, David, for testing for drug
testing for drug driving, exactly. Exactly. I have
He's
to
not
be
a criminal or anything.
Purer than the driven snow. So in those circumstances, of course, you are much more likely to be searched because there's intelligence already existing about the nature of the motor vehicle and your prior criminal record and all sorts of things.
Are they doing that the same for alcohol driving? Do they keep picking up the same people who've been done for drink driving?
No, I don't think so. I don't think so.
Outrageous,
I don't think so. I could be wrong, but I don't think so.
Sorry, Steve, you...
I was just going to say, when they first started to do this sort of random drug testing, the average positive rate was around about 2 or 3%. And that seems more likely as a more accurate kind of, you know, there are not 10% of people driving stoned on the road at any one time. That's just simply not true. There's some, but not that many. And then the police have that detection in their car that reads number plates. So if your number plate is associated with previous charges and so on, had a client once he tested positive and his girlfriend was driving his car and she was stopped about 7 times in 3 weeks. She wasn't a drug user herself, but driving her boyfriend's car. I remember that quite clearly. And
yeah,
she kept
it came before
harassed.
Me.
You know?
I told her to get a new boyfriend.
A new boyfriend. He wasn't worth it. Get a new car, get a new boyfriend.
Yeah. So some states are really progressive, like Tasmania. They just do an impairment test if you get caught driving under the influence. Oh, sorry. Yeah, so Tasmania is pretty progressive. They do like impairment testing if you get pulled over. And we also know, Canberra also has a personal limit of 50 grams for personal use. Can I ask, what protections do we have under the Constitution, say like Section 117, for discrimination from people that say reside in these states and are travelling and might be in New South Wales or Queensland and might have, say, 30 or 40 grams on them, which wouldn't be a problem in their state, but obviously here it would be.
Tasmania is fantastic. It's the only state in Australia that has a medical exception for drug detection driving. And that says that if you have a prescription and you're using in accordance with that prescription and you're not driving under the influence, so you pass the impairment test, then you have a defence when and if you go to court. In practice, they just don't prosecute those matters. So you're right, Tasmania is, and interestingly, although I'm not suggesting that's connected, it's also the only state that has a lowering death rate on the roads. Go figure. But you're right, it's progressive. Second question, the constitutional issue. Good question to ask David Shoebridge later today. But short answer is that it is an impairment of trade between the states that is covered. Now, if cannabis was legal in Queensland, yeah, we can dream, then perhaps then you could get some traction. But the best we've come to anywhere is the ACT, where it is decriminalised. It's still a criminal offence, and worse still, it's not a state, it's a territory.
Yeah, so my understanding was Section 117 would cover people that were discriminated from being, say they were a resident of another state and then getting persecuted under a state law in a different state. So obviously that, and Section 109 would override that state law federally.
A differential in penalties is not a discrimination. So there's still a penalty in the ACT of $100, is that right? 100 and something like that, for possession of a prohibited drug. So the fact that you can be dealt with by 2 years jail in New South Wales when you cross over the border to Queanbeyan is not going to trigger that. That's my understanding, but hey, give it a go.
Okay. Can I ask one more question as well? So I've been studying cannabis for quite a while, and hemp obviously, and I'm finding inklings of it everywhere. You know, people have been using it for thousands of years. Egypt, it's on the pyramids.
Right in.
Oh, sorry, in Egypt, it's on the pyramids. You know, it's even in the biblical scriptures, in my opinion, open to interpretation, though, obviously. Can I ask what sort of protections may we have for people of faith or who practice religiously, who require, you know, through ceremony or something like that, use of this plant?
And it's a good question. And back in the 80s, I think Steve and I both represented people who were, what is that religion in Ethiopia, where cannabis is, you know, part of the ritual.
Rastafarian?
Rastafarian, thank you. And there's a decision that it doesn't trigger the freedom of religion trigger by the Constitution. But think about constitutional law, as we all know, implied rights, freedom of political expression, Mabo, terra nullius, these things can change, and there's lots of room for retesting them. And I agree with you about the Bible. I also think that dropping a couple of tabs as you're walking down the mountain is pretty common in these areas as well.
We have another question here.
Hi, look, back in the 90s when the swab testing was still kind of rudimentary, there was a blood testing used to be a kind of like byline maybe for proving your actual intoxication levels. Does blood testing still exist even in, say, enforcement where there's a drug that can't be easily determined, or is actually being under the influence sort of a bit of a safe zone?
We were talking about this over breakfast this morning. The short answer is if you're involved in firstly, if the police suspect you're driving under the influence, they have the power to apprehend you and take you to a hospital and force you to have a blood test. And that's how they used to do it before drug detection laws. That power still exists. Secondly, there's a protocol, which is that if you're involved in a motor vehicle accident where there's injury or death, serious injury or death, then you are automatically taken to the police station and blood tested. That blood test is then taken to a lab to assess the levels, and then it's given to an expert forensic pathologist who determines, in conjunction with the police statements of your behaviour, perhaps the manner of driving, perhaps you were staggering, drooling, whatever, then they can form a conclusion that you were driving under the influence and you can be prosecuted for that charge. That applies to illicit drugs, including cannabis, and prescription drugs, and we think it also applies to psilocybin. Because, you know, many people are, well, I can't smoke, I can't do, you know, amphetamines, whatever, so I might as well do mushrooms because it's undetectable. And you're right, it's undetectable on the lick stick, but it's probably not undetectable on the blood test.
Just a quick, not further to that in a way. Because we always like to prepare for MardiGrass and not just talk off the top of our heads, the last few days, just looking at some statistics from the Centre for Road Safety, New South Wales Transport section. And every year they put out statistics around, you know, crashes. And this quite interesting, you know, nerdy, but interesting information about, you know, different things. So not just people who are, in terms of the hospital connection, anyone who is involved in a car accident as a driver or a passenger, who might die, for example, and be dealt with, or be, you know, their treatment sort of dealt with through the hospital system, that all feeds in for statistical purposes into how many people, you know, were driving with alcohol on board, for example. So that's sort of useful information, not just for charging live people, but also getting some background information about the prevalence of, or reasons for crashes, and whether, speed or whatever other reason, as in driving too fast rather than methamphetamine. But what's the cause? So they've got all these charts about different things, and they've got a chart about the number of, where alcohol is a factor into death or serious injury, etc. For year after year after year, they have all these numbers, interesting enough in their own way. But they do not have a chart for drug-related deaths or drug-related accidents. They just can't prove it. It's one of those interesting absences from the official documents that although they bang on and do all this testing about drivers and so on, and there's all this sort of rhetoric about, cannabis causes car accidents, well, maybe. But in terms of the official statistics, there is no statistic, there is no table in that annual report about how many people were involved in car accidents as a result of drug use. Interesting.
So when people say the drug testing regime is a road safety measure, we all know what that means. It's bullshit. Yes.
Thank you. To what extent, it's often maintained recently that cannabis possession no longer contributes to incarceration in New South Wales and Australia. Is that actually correct, both in New South Wales and elsewhere?
There are still people who are incarcerated for possession of cannabis. The numbers are decreasing, and it's pretty hard to tell because sometimes it's combined with other charges. So if I was a magistrate and somebody was before me on a cannabis charge and say their 10th drink driving charge, I would probably jail them for both because you don't really want to give them another fine for the cannabis for when, and make their life worse. You might as well concurrent the sentence. So that's one way in which people are still jailed for possession. But the much more important way is use of good behaviour bonds. And even without conviction, you can be on a good behaviour bond. But often with conviction, you're on a good behaviour bond. And so what happens is people breach that bond for whatever reason, and then they're resentenced on the cannabis matter, and then they are sent to jail for the cannabis matter. So it's a myth to say no one goes to jail anymore for possession of cannabis. They do, and particularly in those two ways. Steve?
It's about 50 a year. I'm a bit of a stats nerd. It's about 50 a year out of 10,000. So it's not a large number, but it's still there. There's a, it's more than an asterisk, put it that way. There's some people. And on the way the statistics are presented, it's meant to be for the most serious offence that's charged. So not just as a, additional offence or something, the most serious offence. So a bit hard to unpack that and get behind what that number means, but it's a pretty consistent 50 odd a year.
And then, of course, there's a whole other subset of people who oppose being searched, or who don't turn up to court, or who commit a resist arrest or offensive language or something else because it's scaffolded with a possession of cannabis charge. So you get a lot of young people in particular who are pulled over, are joints found, and they run. Well, they're not jailed for possession of cannabis, they're jailed for escaping police custody. Or they're not jailed, or who then trash the police van when they're in the back of it, being arrested because of the cannabis charge. So it's probably, for example, offensive language doesn't carry a jail term, but there's a lot of jailing associated with offensive language, especially in Western New South Wales and areas where there's high Aboriginal population. So there we go.
Hi.
I was going to say we've got one more question and then we're going to wrap it up. So if anyone has got any more burning questions, you're welcome to chat to these lovely gentlemen over the weekend, or you can come back tomorrow at 11 a.m. when we have another legal session. So please go ahead.
Thank you. Hi, I'm Sue. Thank you, David and Steve. So we had a conversation before about driving, and it made me think that I used to be a bartender many moons ago. So we as bartenders used to have to do an RSA, which I found on a chemistry level very responsible to know my driving limits. Could there be down the track any form of responsible of like drug and alcohol? And then maybe I've always thought about when people take on a license that we do maybe a first aid and a responsible drug and alcohol certification.
There's a very close relationship between alcohol blood level, breath testing, and impairment. In other words, although it's not 100%, I don't drink at all, And if I had a glass of wine, I would probably not be safe to drive. Whereas somebody who drinks a few glasses of wine every night probably would be, and our blood alcohol level would be the same. But by and large, there's a pretty good approximation of affectation and level. It's much harder with THC. And there's a whole range of reasons for that. Idiosyncratic digestion, building up a resistance in terms of its use. So I think that the whole impairment issue, in a way, with cannabis is a furphy. I want to make T-shirts that say, just like any other prescription drug. We have a system that works for Valium, for barbiturates, for dexamphetamines. We have a system for anti-anxiety medication, for taking a Valium when you go on an aeroplane. We have a system that's worked for decades and works in many other countries without worrying about THC. I often think that if cannabis was a new drug, let's call it weed, and it came from America, and it was this new drug, no one would, and it does all these fantastic things for people on prescriptions, 1 million prescriptions in Australia now, then we wouldn't be thinking about, oh, does it impair people for driving? Does it not? Should we make it illegal? Should we test just for detection? It just wouldn't be an issue. So I think that the impairment rabbit hole is from a policy point of view, good for alcohol, not for THC. Let's treat it like every other prescription drug. And that way, I think we'll get to a better outcome. I get worried when all these researchers are doing impairment studies and all the rest of it because it's so idiosyncratic. We don't want to throw the baby out with the bathwater.
I agree.
Okay, well, thank you so much for that very enlightening session as usual.